What are my rights when it comes to workplace harassment and hostile environments?
Every employee, regardless of where they work, has the right to be free of harassment and a hostile work environment. And we should talk about the two. People sometimes confuse harassment in the normal sense of the word or the common definition of the word harassment. Under the law, harassment has a very specific definition, and that definition is that you're being harassed on the basis of a protected characteristic. A lot of people tend to believe that if the manager raises their voice or is on them to get their job done, that they're being harassed. And in that limited fact pattern, it's typically not harassment because the manager is focusing in on the work. Now, given that example, let's say, for instance, that only the men are being harassed or dictated that they need to get their work done, but the women aren't. In that particular case, the men might say, look, I'm being harassed on the basis of my protected characteristic. That is, I am a man and I'm not being treated like everyone else. So there are two forms of harassment. One is hostile work environment that we sort of discussed just now, and the other one is quid pro quo harassment or sexual harassment. And quid pro quo is Latin, and it simply means this for that. And in quid pro quo sexual harassment, there has to be an exchange. And the exchange is always going to involve sex on one part and some tangible benefit on the other. And that benefit can either be granted to you, for instance, by way of a raise, a promotion, or it can be taken from you. You're not going to get that raise and you're not getting promoted. In fact, you're getting fired. So there are two different forms of harassment. One is hostile work environment, and the second is quid pro quo.